Hello, my name is Eric Willison. I'm an Ohio attorney, and any legal education that I'm imparting today will deal with the state of Ohio. Ohio's laws are different and similar to everybody else's laws usually, but because of those differences, and because I'm only certified to practice law in the state of Ohio, people watching this video in Ohio should be the ones who are being educated. Anybody else taking this as legal advice would be acting at your peril. Further, I am not your lawyer. That's because I've never met you. I don't know the situation, the factual situation of your particular case. This is, again, for educational purposes only. I've been practicing law in Ohio since 1996, mostly in the area of landlord-tenant law. I've been doing evictions both for landlords and for tenants since 1996, whether conducting the evictions or fighting the evictions or even evicting subtenants for tenants. And today we're going to talk about the CDC Eviction Moratorium and the fact that it is ending. And we know it's ending because it's been extended several times. Let's get back to the basics real quick as to what the CDC moratorium actually is for those of you who might be coming to the game a little bit late. The Center for Disease Control in Atlanta, which is a part of the executive branch of the federal government, decided that people getting evicted from their residences because they could not pay the rent and possibly might have to go into some sort of group living organization might spread the COVID-19 disease. And therefore they issued an order purporting to bar evictions all over the country. Now, some courts in some states said, no, you don't have that authority. Other courts said they do have that authority and decided that no evictions for failure to pay rent if the tenants met certain conditions would be allowed if they signed what's called a CDC declaration. What were those conditions? Number one, if your tenant or if a tenant earned more than $99,000 per year as a single person, then you were not eligible for the CDC moratorium protections. Also, if you were a person who was married or living with somebody else long-term and you together made more than $199,000 per year in income, then you are not allowed to take advantage of the CDC protections. However, most tenants don't fall into those categories. So the second category would be that you had tried, even though you've fallen behind on the rent, you tried to help the landlord to find various governmental assistance programs. Here in Central Ohio, there's a program called Impact, and Impact has a lot of federal money where if you as a tenant were to go to them and say, hey, I lost my job because of COVID, because my place of employment shut down, and COVID was the cause of the fact that I couldn't pay rent. Well, Impact would come through with money for the landlord in a lump sum to catch you up on the rent. Now, it's not necessary that the governmental organization or rental assistance program actually provided the money, but it was essential that you tried. And so that would be the second part of the CDC affidavit. The third part is that if you were to have to leave, then you and or your family would have to leave and would have no place to go other than possibly like a group setting. Maybe you'd have to move in with your brother or move in with some sort of group housing situation. That would make it more likely that COVID would spread, and therefore that would be another condition of the declaration. So what would happen is that tenants would sign these declarations, they'd come to their hearing, they'd show this to the court, and the court would not dismiss the eviction. But what the court would do is they would say, okay, we're going to continue this eviction for a period of time. And then we'll come back and we'll see if the court, if the CDC declaration and that CDC eviction moratorium was still running or not. Well, it had been running in late 2020. It was supposed to end at the end of December of 2020, but it got extended at the last minute to the end of January. And then at the very end of January, it was extended again to the end of March. And at the very end of March, it was extended again to the end of May. Very end of May, extended again to June, then it was extended again to July. Well, all during that time, some landlords had challenged this in federal court, and some federal courts had ruled both ways. Some courts had said, no, this is unconstitutional. Others said that it was constitutional. Now, regardless of the ruling, either or both sides would appeal this to the appellate level courts, the mid-level courts, which would then make a ruling. And then that, of course, got appealed to the Supreme Court. Now, to get to the Supreme Court, you don't automatically get in front of the Supreme Court. You have to convince the Supreme Court to take the case. But what they did was, the people that lost at the circuit level had not only appealed, but they had asked the Supreme Court to stay the effects of the decision of the lower court. So here's the decision from the United States Supreme Court. Remarkably, it is one page. And what it said was, Justice Kavanaugh, and he said, and I'll quote this, I'll leave out the citations because that doesn't really add much for most people's understanding. I agree with the district court and the applicants that the Centers for Disease Control and Prevention, that's the CDC, exceeded its existing statutory authority by issuing a nationwide eviction moratorium. We're going to skip the site. Because the CDC plans to end the moratorium in only a few weeks, on July 31st, and because those few weeks will allow for additional and more orderly distribution of the congressionally appropriated rental assistance funds, I vote at this time to deny the application to vacate the district court's stay of its order. So as we said before, the district court in this case had ruled in favor of the landlords and said the CDC eviction moratorium is unconstitutional. However, the district court, realizing this was very important, said, but we, the district court, are going to stay the effect of our order. So the eviction moratorium will stay in place until a higher court gets to take a look at it. But for now, it's unconstitutional. So it went to the higher court. The higher court agreed with the district court, but also the stay was remaining in effect. So here comes Kavanaugh saying, I agree, and speaking on behalf of the Supreme Court, he thinks everybody else will agree, that the CDC exceeded its authority and that it's unconstitutional. But, he said, we're going to leave the stay in place because it's only going to be for one more month. And during that month, things can get sorted out. So let's finish up here. In my view, clear and specific congressional authorization via new legislation would be necessary for the CDC to extend the moratorium past July 31st. So, what it's saying is that it could be constitutional if Congress did. He's not saying it would be, but it could be constitutional if Congress had set up a law which would allow the CDC moratorium. But that's not what happened here. Instead, what happened was the CDC as a government, as an executive branch organization, just took unto itself what is arguably a congressional power and mandated this stay of evictions over all of the states. So at this point, we've got, today is the 31st of July. This is the last day of the eviction moratorium based upon failure to pay rent. Now, I keep saying failure to pay rent. The CDC eviction moratorium never purported to stop other types of evictions. So if your tenants had an unauthorized dog, if they had an unauthorized occupant, if they were dealing drugs from the premises, if they were damaging the premises and wouldn't stop damaging the premises, or disturbing other neighbors and wouldn't stop disturbing other neighbors. All of those would proceed normally under the normal way that you would proceed as a landlord to remove those tenants. Maybe the lease agreement was over as to its duration. It was supposed to end on March 30th and not go past that. Well, April 1st rolls around. You're not getting rid of them for failure to pay rent. You're getting rid of them because the tenancy is over. So all of those types of evictions that are based on those reasons could still go forward under the CDC Eviction Moratorium. And so a lot of landlords were trying to say, well, in addition to not paying rent, they also were doing this. And that would be an independent basis for the eviction, and therefore that would succeed. But what I'm talking about is landlords whose tenants were doing everything right except for failing to pay rent. And so now that is over as of the first day of August. Now, if the tenants are behind on the rent, you go through the normal eviction process of posting a 3-day notice of the type that is mandatorily required with the mandatory wording on the door, and then you wait your 3 days. In some spaces in Ohio, it's 3 business days, and then you will file your forcible entry and detainer action with the court. The court will set a hearing. At the hearing, you as the landlord get to tell the court why you should be able to regain possession of the premises, and you as the tenant get to tell the court your side of the story as to why you should be able to stay in the premises. The court makes the decision regarding possession, and if it's in favor of the tenant, then the whole thing is dismissed. If it's in the favor of the landlord, however, then the court will issue, upon an application from the landlord, a writ of restitution, which will get posted on the door, telling the tenant you have a certain number of days to be out, or you'll be set out. If those days pass and the tenant is still there, then the landlord will apply for a press of fee for set out, and that's just sort of a meeting with the bailiff and locksmith of the landlord's choosing, and a work crew of 4 or 5 big guys with garbage bags of the landlord's choosing, and the bailiff from the court. They will all meet out at the rented premises, and the locksmith will go to work on unlocking the doors and changing the locks. The work crew will go to work and start taking stuff out to the curb, and the bailiff will be there to supervise. If the tenant makes trouble, the bailiff will call in the police, and the police will say, tenant, you've got to get out of here. If you stay here, you'll be trespassing and charged with trespassing and arrested. And so that's how the tenants would have to leave if they refuse to leave. But in 99% of the cases, most tenants with a bailiff and a work crew and a locksmith there, they'll leave if they haven't left already. And so then that is the eviction process from beginning to end. And as far as Ohio goes, there's no more CDC eviction moratorium that will stop the evictions based upon the failure to pay rent.